Hello, everyone. Open source compliance, why and how is the next slot, and I'm very happy to present you some basic insights into open source compliance, why it is important, and how it can be achieved most easily and most efficiently. Many companies don't have any open source compliance processes in place. This goes from smaller companies to large big groups. We have seen in practice that pretty much from small companies to large companies, compliance and non-compliance can be existent. If we take a look at press coverage from the last months and maybe also the last years, we see that some people make their living by simply filing complaints against companies and simply by claiming money due to non-compliance from these companies. This happens in practice. We have assisted companies in several cases against such attacks and successfully defended companies against such attacks. This is something you do not want to have on your table, on your desk, because suddenly you have to deal with compliance, but on in a very short time frame. You have to ensure and achieve compliance within maybe days, if you're lucky, weeks. But this is something you do not want to orchestrate, and you do not want to manage. The better option is, of course, to do this without any time pressure and without any economical pressure behind it. So this happens in practice, but there are other drivers why open source compliance is important. So, for instance, companies may claim damages in case of breach of contract. Any open source non-compliance may easily lead to a breach of contracts with regard to clients of such a company. If you do not provide sufficient information on open source licenses contained in your software, this may be considered a contractual breach. There are other situations where it can be quite critical. For instance, if you want to sell your product as such, so not on a single basis, but if you want to sell your assets, your IP assets, or if you maybe want to sell your company, and if the company's main asset is only software, then it's of course essential for the purchaser to know to what extent is open source software contained in this asset, and to what extent is this asset actually yours. We've seen many cases where open source compliance was not existent at such companies, and in some cases this led to a massive price decrease due to larger IP issues, due to larger inconsistencies, and due to larger cases where such non-compliance led to certain products not being able to be sold under commercial terms, for instance. So this happens. License obligations are easily infringed, as many licenses do require a number of obligations that are easily not complied with. And this can then, well, as said, lead to damage claims, lead to all the other consequences we've just seen. What do you need for open source compliance? First of all, you do need an open source policy. This is actually essential, a policy, a document which outlines the processes that you want to follow in your company, in your project, clear guidelines that simply tell all the involved people what to do with the software, what to not to do, what licenses to prefer, what licenses to avoid, what information to collect, and so forth. So that should actually be your internal handbook. You do, of course, need staff. Without people, it's not possible to manage any compliance. You cannot run processes without people executing such processes. We are not yet there where no more human involvement is necessary. So you do need people, and of course, you do also need a process which is then followed. And finally, you will soon find out that it is not possible simply to manually achieve open source compliance. Doing this by hand, you do need some tools. So coming to the first issue, open source policy, what do you need? You need clear guidelines. You need clear guidelines. What licenses do you want to use? What licenses do you want to avoid? This depends on what you do with the software. It depends on whether you do own patents or not. It depends on whether you use your software in a DRM protected environment with digital rights management in place. It depends on various other questions that you would set up in a use case, and then you would, of course, derive the guidelines and the recommendations with respect to specific licenses from such a use case. How do you want to integrate GPL or LGPL components? LGPL as being one example for a copyleft license. So copyleft licenses may be critical or maybe dangerous in air quotes if you use such copyleft license software together with commercial products with proprietary licenses. Because in some cases, connection of both types of software may lead to the copyleft effect to affect the proprietary part to be licensed under such copyleft license. And if this is not possible or if this is not intended, one should not use such copyleft licenses. Do you have proprietary IP that you want to protect, for instance, patents? This is a question which is essential and should be addressed in such an open source policy. Of course, you have to specify how you document what you do, also how you document your compliance artifacts that you have to provide, such as license texts, such as copyright notices. And finally, I would like to give you the advice that it's better to take a holistic approach, which means do not simply restrict yourself or restrict the process to open source software, but simply take software as such into account. In many cases, we have found proprietary licenses, we have found proprietary software in open source software stacks, in commercial software that has not been identified as commercial software, or even worse, it had been identified, but then pushed to the purchasing department, which again said, well, it's software, we don't deal with it, or it's open source software, and then it got stuck in the middle. No one was competent or felt competent for it, no one dealt with it, so finally commercial software was used within a product without any person ever having taken a look at this and ever having taken a look at compliance with that license. So simply take a look at software as such, and then I think the risk that you leave something out, that some software components are left unchecked, is significantly lower. Well, staffing. Very often I'm asked, well, how many people do you need for your compliance team? And then the answer, of course, is typical for a lawyer, it depends. It depends on the size of your company, but not only of the size of your company. We are currently advising a stock-listed company, one of the biggest German companies there are. They don't have any compliance officer, and they don't need one because they do not deal with software in the first place. In that case, software is simply used for their services, for their products. So this software is not their main asset. And in that case, you may be well off by externally dealing with open source compliance or having it dealt externally, having it covered externally. Whereas in other companies, which are much smaller, maybe even 5 or 6 or 7 open source software officers is not enough. And of course, there are many large companies that employ dozens of people involved in open source compliance. So we've seen everything. If you want some figures, there's a book by the Linux Foundation, Open Source Compliance in the Enterprise. And if you take a look at their figures, you can come up with 4 full-time employees. So that's something which can be helpful in order to convince your company, in order to get the funding for people. But of course, as said, it's not a rule of thumb, it's not a general figure, it's just a first estimation where it can make sense to start thinking about how many people you need. Besides staffing, you do need a process. So every individual single open source component should be checked, should be subject to a release process. Every line of code that you use and that you, especially that you distribute to third parties, should be reviewed. It should be reviewed the license under which the code is licensed, and the license should be legally assessed. And of course, also from a security and vulnerability perspective, such assessment should take place. And then you need to compile the documents that you need in order to fulfill the license's obligations. So in many cases, it's the license text, it's copyright notices. It may be the source code that has to be made available for quite a long time, as long as you at least provide the software. So this is something that has to be ensured that it's taken care of. And you, well, I wouldn't say may check. Actually, you would have to check. It's a must, but in many cases, it's still as an option. You would have to check whether the copyleft effect of the so-called copyleft licenses is triggered or not, because this may also lead to compliance issues. You can use standard questionnaire for that, asking your developers certain questions, how they deal with the software, how it is connected. Of course, it depends on the software, it depends on the type of software that you connect. You can't statically link in a Java environment, you can't do function calls in specific other environments. So that's something that can't be standardized too easily, but at least some questions can help to get a first understanding. And finally, you do need a toolchain. A toolchain which simply performs the tasks that do not scale, the tasks that may cause a lot of efforts to be put into. So what you have to do, you have to first of all get hold of all the components that you use in your products. And this can easily go into the hundreds or thousands. So software package, if you take a Linux distribution, there are several 100,000 files, about 90 licenses that are initially identified by standard scanning tools. In practice, it's a bit less than, but just in order to give you some figures, this is the number of files of licenses that we're talking about in an average software stack. You can do this by hand if you have very small software pieces, if you have very small pieces of code, a few lines of code only, but the moment it gets larger, it's much more difficult to do this by hand, which means you usually need some toolchain support. There are a number of tools out there. I won't go into detail there, but as said, it's probably not an option to go without. You need to correct errors. Not all the tools are working properly, and there are many false positives or false identifications. This has to be corrected, and the tool has to provide a respective possibility to do so. And then finally, such tools should set up your bill of materials, as we call it, which is the list of all the software components and all the licenses applying to these software components, or the copyright notices to the extent they have to be extracted. This is something that simply should be done by a tool, as doing this by hand is possible, as said, on a small scale. But the moment you go agile, the moment you have more than just one release per year, the moment you have more than just a handful of components, it's not feasible in practice anymore. And finally, you have to identify the legal license obligations, which means it's not just about compiling some documents, it's not just about providing copyright notices, but it's also about identifying what additional requirements these licenses demand. So as mentioned earlier, some licenses prohibit use in a DRM environment. So the moment you use software on an iPhone, for instance, you may not be able to use any GPL v3 software, or respectively licensed software, as this is technically possible, but not legally. And of course, there are other requirements that you should take into account that go beyond the mere provision of information, which may prohibit the use of software simply due to legal restrictions. We have developed a tool that can help with that regard, and this is something you can develop yourself internally as well, simply by providing standardized advice for single licenses, and by taking such licenses and by identifying use cases then. So we've made good experience with that regard in practice. When it comes to a large scale scan, when it comes to open source compliance on a larger scale, then it helps if you simply go through a checklist and if you simply go through a system which tells you what is possible and what is not possible in practice. So with that regard, it makes sense. That's also what we recommend all companies in practice, to set up a use case. How do you want to use the software you're using? How do you want to make use of it? Do you want to use it internally only? Is it included in your products? Is it provided as a service? And then derived from this use case, you assess the licenses and check whether your use case matches with the licenses or not. In addition to this, I would have loved to bring to you the figures of our latest open source compliance report, which is out now for a few days. Unfortunately, this report is only available in German language yet. We are working on an English language version, which hopefully will come out soon. This report is actually based on a Bitkom survey where 800 companies, more than 800 companies have been interviewed by phone with regard to their use of open source software. And one focus of these interviews was also open source compliance. So in this report, you can find figures on what compliance measures are taken in these companies, within the companies. This can help to self-assess whether you are kind of, well, up to market standard or maybe below. So once the report is out, I'm happy to send it over. Just drop me a line and I will send a copy over to you. Unfortunately, as said, we are still working on the English language version by now. But anyway, this may be helpful in order to assess what is actually done out there. Am I completely wrong if I'm doing this, or if I'm not doing certain compliance measures? This surely can help. So as a conclusion, what has to be done? Well, you have to do some software testing. You have to set up a bill of materials. You have to check and scan the software. And usually you can't go without any tool support with that regard. Otherwise, it will be much more work than doing this in an automated or at least semi-automated way. And of course, other requirements besides mere information provision requirements have to be obeyed and complied with as well. So all the licenses that do have additional restrictions should be identified, and of course, these restrictions should be complied with. That's it. I think we are running out of time, so I'm happy to take your questions now. Thanks for listening. And yeah, as said, if anything was unclear, if you have any additional questions, please ask. Many thanks, and well, waiting for your questions.